Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, California, we get to talk about you, but in a roundabout way, I'm also going to talk about the state of Washington, in particular, two legislators who knowingly sponsored an unconstitutional bill this last legislative session. What am I talking about? Well, could you imagine if you guys could go to church but only one Sunday a month? Can you imagine if you were free from unreasonable government searches and seizures but only on even numbers of days? Can you imagine if you were allowed to speak freely but only every other month? Sounds kind of crazy, doesn't it? Well, in the state of California, you could only purchase a firearm once every 30 days, according to a California law. Well, at least according to a now ruled unconstitutional California law. We're going to talk about the case of nuanced v. Bonta because of this law, deservedly so, just took it on the chin big time from where? That's right, the Ninth Circuit. So today, let's spend a few minutes and let's talk about there are no quotas on your constitutional rights. Okay, America, we are talking about a law that I'm sure has saved countless lives in the state of California, and that is the law that was enacted way back in 1999. So if you think that these unconstitutional gun laws will get on up and get resolved right away, you got another thing coming, okay? 1999, California started limiting the amount of handguns you could purchase in any 30-day window. The law, of course, was expanded over time to now include every single type of firearm there is. Well, then along comes the Bruin opinion, where we got to kind of justify everything through historical analogs, and that led us, of course, to the case of nuanced v. Bonta, a now quite successful challenge to California's one gun every 30-day law. They have prevailed at the district court level, and now they have prevailed in front of a unanimous three-judge panel of the Ninth Circuit. And I want you to understand what a fantastic piece of litigation this really was, because this was a facial challenge. This did not just apply to nuanced. This applied to every single California resident, and as we know, under a facial challenge, plaintiffs must establish that no set of circumstances exist under which the law would be valid. And that is an incredibly lofty burden, one that many plaintiffs fail miserably at, and many of them don't even try. But this again goes to show what an amazing piece of litigation this is. Of course, it's brought to us by our good friends over at the Second Amendment Foundation and the Firearms Policy Coalition, which means we got links down below for you to both show them some love. Now, as you are aware, California's argument at oral arguments, which is something of a spectacle to behold itself, is that the Second Amendment only protects the right to keep and bear an arm. And since this was not affecting either one of those, and that, since you could purchase a firearm at some point whenever California determined that it would be appropriate, there wasn't even any Second Amendment implications here. That was actually one of their arguments. Now, the three-judge panel of the Ninth Circuit obviously was not too impressed with that. This core Second Amendment right wouldn't mean much without the ability to acquire arms. Thus, we have consistently held that the Second Amendment protects ancillary rights necessary to the realization of the core right to possess a firearm for self-defense. As a matter of fact, I want you to understand, California, how much your state government hates you. Because they literally argued that as long as you are able to possess a single firearm, that's all the Second Amendment guarantees you. That was actually their argument. This is how the three-judge panel dealt with it. California suggests that the Second Amendment only guarantees a right to possess a single firearm, and that plaintiffs' rights have not been infringed because they already possess at least one firearm. California is wrong. For these reasons, we easily conclude that the plain text of the Second Amendment protects the right to possess multiple firearms, and we are not alone. The D.C. Circuit has held that limiting the number of firearms an individual can purchase or register within a 30-day period interferes with an individual's undoubted constitutional right to keep arms, plural, in his or her home. Now, California tried to say, listen, this is just a mild limitation on the sale, very similar to B&L Productions v. Newsom, a case that the United States Supreme Court recently did not accept review on. The court very carefully distinguished those cases as follows. First, we have held that the Second Amendment does protect against meaningful constraints on the acquisition of firearms through purchase. And if the Second Amendment's plain text protects the ability to possess multiple firearms, which we conclude that it does, then it also protects the ability to acquire multiple firearms. Now, to Representatives Farvar and Ormsby out here in Washington State, you know who you are, the ones who sponsored House Bill 1132, which was a carbon copy of this California law. And we said all the time during the legislative session, hey, you're going to push this through anyways, even though you know there's constitutional issues. Now, that bill ultimately ended up dying in committee, and let me give both of you a piece of advice. That's where it should stay, okay? Because as we said on multiple videos when we talked about a quota on constitutional rights, the Ninth Circuit put it this way. We are not aware of any circumstance where the government may temporarily meter the exercise of constitutional rights in this manner, and we doubt anyone would think government could limit citizens' free speech right to one protest a month, their free exercise right to one worship service per month, or their right to be free from unreasonable searches and seizures to apply only to one search or arrest per month. We could go on. Okay, and then, of course, the state of California said, well, actually, we don't really need a historical analog. We just need something relevantly similar. You know, we just need to be kind of, not even in the ballpark, but somewhere in the city where the ballpark lies. That's right, I am talking about the more nuanced approach. Something that you all might as well get used to reading because you're going to see this quoted over and over and over. Now, the Ninth Circuit thinks it comes from Bruin. It doesn't. It comes from Rahimi. But the Ninth Circuit, and very correctly here, points out that this is not a case where we even need to go to a nuanced approach, as they put it. But we need not wrestle with this question here because a nuanced approach, whatever it means, is not called for in this case. And the reason the Ninth Circuit says, listen, a nuanced approach is not called for here is that the problems that you are trying to cure through this legislation are not new and they are not unique. You are talking about gun trading. You're talking about arms trafficking. You're talking about trying to control crime. Those have existed since really the beginning of time. And so as the court then puts it, in sum, the modern problems that California identifies as justification for its one gun a month law are perhaps different in degree from past problems, but they are not different in kind. Therefore, a nuanced approach is not warranted. And so, in upholding the trial court's finding that this law is unconstitutional, which it is, a 3-judge panel of the Ninth Circuit has ruled the Second Amendment expressly protects the right to possess multiple arms. It also protects against meaningful constraints on the right to acquire arms because otherwise the right to keep and bear would be hollow. And while Bruin does not require a historical twin for a modern firearm regulation to pass muster, here the historical record does not even establish a historical cousin for California's one gun a month law. A huge win. The state of California, I'm sure, has already crapped its pants and is working on the appeal to an en banc panel of the Ninth Circuit where, God help us, once that happens, everything always seems to go to hell. Kudos to the Second Amendment Foundation and to Firearms Policy Coalition. You guys did a bang-up job with this. The case, once again, is the Wynn v. Bonta. We're going to link up the court's order down below. You don't have to take our word for it. You can geek out on it for yourself. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.